Thank you so much for appearing today in front of our committee. Last week it was really interesting because I was actually at a grade 10 class, doing a civics class, where we were discussing the report and about young students, 1 in 4, having a sexual assault case in the first 8 weeks of going to school. And we got into the judges and we started talking about the judges. And I don't believe many Canadians, because I know the teacher who is very up on what goes on in Canadian law, he could not believe that Canadian judges were not already in the field of understanding sexual violence when appointed to the bench. And I explained, you could be a bankruptcy lawyer, you could be, you could be somebody who does real estate law, you could be any of those things. So I think it's really, really important. But recently we have seen the province of Ontario coming out, I think it was March 15th, and I was really, and this is how the conversation continued with the students. And they were concerned too. Why would we see some provinces say we're not going to make this happen when we know that we have had cases where it's very obvious that because of the lack of training and the lack of understanding, that we aren't appointing or we're not getting the best results or the bet for the judicial system. So what do we do with some provinces that do not want to do this? And I recognize that we're talking about specifically new judges here, which is great. But those current judges that are sitting on the bench, is there anything that we would be able to do, or is that going to be 100% provincial jurisdiction?
Well, I think one of the things that we can do without infringing on judicial independence is to advocate that and put pressure on the judiciary and on even governments, sitting ministers of justice, for instance. In the administration of the court, I think there's nothing wrong with shining some light on whether or not the Chief Justice is assigning sexual assault trials, to a judge who doesn't have any training. And the more transparency we can, I think, impose on, and the more pressure that we can put on the provincial system, I think is helpful. And advocates are already doing that. There's a lot of advocates that have picked up on this bill and have started to put pressure on provincial governments. But I've had very good conversations with Premier Christy Clark, who's very supportive of this bill and is looking to see what she can do at the provincial level. Premier Brad Wall, I've had conversations with Premier Brian Pallister. I've also had conversations with leaders in the Atlantic region, and I've sent either a letter or spoken to every single premier, and also letters to all of the ministers of justice and attorney generals about how this can be done without infringing on the judicial independence, and why this would be important. It's as simple as amending the criteria.
So much. And you had, at the very beginning in your comments, you talked about the Court Watch program, and I think that must have been a fascinating time. What were some of the things that you did see during your time as a student, looking at what happened in the courtrooms to some of the issues? And when we're also looking at this bill, I'm going to do this twofold. There has been talk about, will this make it biased towards the complaint rather than the accused, and what are some of the things that we should look at there, and if you could talk about the Court Watch program and why this is really balancing the judicial system rather than putting it towards one side.
Well, to expect that people that are involved in the justice system have the appropriate training seems like a no-brainer to me, and that someone would say that somehow this would bias the system is ludicrous. We're talking about basic knowledge of the law in sexual assault, and then furthermore, a level of comprehension and understanding around rape mythology and stereotypes, language, all of these things. It's not present right now, and I think I've spoken to a lot of people in the system who welcome this, who think this is a wonderful idea. It's a long time in coming, and that this will be a good thing. And that's, judges, lawyers, police, advocates. I can't see why we wouldn't do something like this. But no, it's not about creating bias. It's about creating a more informed and an educated, trained, and a more transparent system. On the issue of the Court Watch program, that was just an example. I've worked I've done lots of advocacy work in my life, but that just happened to be one project I was involved in. And every single case that we set in on, we heard things like that, particularly around sexual abuse cases. And some of those stereotypes still, they're still prevalent. And that's the problem with stereotypes and myths. Unless you learn differently, you bring that to the courtroom. People bring that to the courtroom. So I think training goes a long way, and that's what this is about. It's about making our system more transparent. It's about making our system more, and really, to be honest, for me, it's about building confidence. Women do not have confidence in our justice system when it comes to sexual assault law.
Hi, thank you. There was one comment also. You got it indicated that you would like to see written rather than just oral presentations on what their judgment's going to be. One of the concerns is that that's going to delay time, that they already have enough work. I think there are quite a few holes right now and a few gaps in those being appointed, but why is it necessary, and why do you think the best thing to do is have it in a written response rather than just oral?
Written decisions are of higher quality. That's the bottom line. When a judge, like any person, has to write out their arguments, they do it in a more thoughtful way. The hope is that they'll use more thoughtful language, because a lot of times when we see these things happen, it's in oral decisions. And another issue is complainants want to have a record of the decision. We've heard from various advocacy groups who emphasize how important it is for complainants to actually have a copy of the decision. So currently, if a judge gives a decision orally, a complainant leaves the courtroom with no record of what they've just been through. And obviously, the traumatic nature of the proceedings, complainants just want to be able to review that, especially after the fact, when they can process it a lot of times more easily. And when they do, the complainant has to, when they do want to have access to an oral decision, they have to jump through all kinds of hoops, and it's also costly to get a copy of the trial. That's just one issue, but it also is about increasing transparency. When a decision is written, it's much more accessible in terms of how it's available to even researchers, not just complainants, but researchers, advocates, academics who are trying to do work in this area. And it also, remembering, as I said early on, sometimes the only reason we know these things are happening is because the reporters in the courtroom heard it and wrote it down. And so written decisions also ensure that decisions can be scrutinized by the public and the parties to the case, that they can be scrutinized. And this is an area where we need more scrutiny. There's no doubt about it. So I think there are concerns about written decisions being more costly. My hope is at least we have more written decisions, and if that is a huge cost burden, then at least that oral decisions be transcribed and readily available, that you don't have to go through a FOIP system or a freedom of information, and that you don't have to pay, particularly the complainant having to pay to get access to this. To these records and decisions. So there's ways in which I think we can make the system much more accessible and transparent.
And as you're indicating, I think a written decision will also make sure that the person speaking are going to be much more thoughtful with their comments, especially to the victim and to the accused as well. So I think this also deals with that issue of those harsh words that may have been said in the past, that now that it's got to be on a piece of paper that can be distributed to every media source throughout the world, that they're going to have to be much more accountable as well.
Mm-hmm. So. Funny how that happens.
Yeah,
but it does.
Thank you very much.
Excellent. Well, I just want to thank you, Ms. Ambrose, for bringing this bill forward. As you've heard from the committee, when we brought our report forward on violence and taking action on violence against women and young girls, we saw the need for better training from the start of the process to the end. And so we thank you for your time today. And